This is your chance to ask Todd Lutsky your estate planning question, so we'll open up the studio line so you can do so. The number is 888-205-2263. Again, that number is 888-205-2263. If you have a question about your estate plan for Todd Lutsky, this is your chance to ask it. Again, that number is 888-205-2263. Mr. Lutsky, how are you today?
I'm never better, and you?
I'm doing well. I saw a fantastic statistic the other day, actually, about the Australian economy.
You did?
Their biggest export?
Yeah.
Boomerangs.
Really?
Also happens to be their biggest import.
I get it.
Just wanted to let you know. I thought that was rather interesting. Let's talk a little bit about gifting as an estate planning strategy, specifically to potentially deal with estate taxes. Walk me through the considerations of someone who might be looking at gifting as a way to manage their estate tax burden.
Well, I think the first thing you need to think about, which is the size of your estate, right? I mean, some people come up to you and they say, "Oh, geez, I got to start making some gifts because I got to save on estate taxes, and I know if I gift away assets, I can save on estate taxes." Well, folks, remember, the exemption currently for 2022 is $12,060,000, and for 2023 it's going to be $12,902,000. So that's a big number, and if you're married, it's double. It's $24 million and change. So first and foremost, Chuck, I think you got to say, well, if I'm under that, then the gifting has zero tax motivation, right? Because whatever I gift, if I don't gift, if I'm under that exemption, I'm not going to pay federal estate tax. If I gift, I'm not going to pay federal estate tax. So there's no benefit in gifting.
At the federal level.
At the federal level. That's the first analysis that I would make. Secondly, even then, look at the state level. Your state exemptions where you live are different. They vary, right? It's like, in Maine, it's relatively high, $5 million and up. I think Connecticut has jumped up to somewhere around $9 million. So, Massachusetts, you're stuck at $1 million. So it really depends on your state as to whether or not you're over that exemption. So let's say you're worth $2 million in Massachusetts. I have no federal, and with basic planning, I have no state estate tax. I don't need to gift for saving of estate taxes. If that's the motivation, then I don't have that motivation.
Yeah.
And the reason you don't want to just gift is because you might say, well, fine, I'll gift away an asset. But what if the asset I'm gifting away has a huge built-in gain? Stock that has increased, or
it's not just cash from a bank account, but a physical asset or a ownership in a company or something like that.
Right. I mean, what if the idea that the item that I want to gift happens to be a vacation home that was bought, years and years ago, or given to you by your parents, and then you want to give it to your kid? Well, you're giving your child the built-in gain. So while I might not be getting any estate tax benefit depending on the size of my estate, I am actually creating, it's like I'm the legislature. I'm now creating a tax by giving away an asset that has a built-in gain because I'm giving that child that gain. And that creates a tax that really doesn't need to be there, because if I kept it and then my kid inherited it, they would get a new basis equal to fair market value on the date of death.
Talking with Todd Lutsky, estate planning attorney with the law firm of Cushing & Dolan. If you have a question for Todd about your estate plan, this is the time to call 888-205-2263. When we come back from our next break, it's going to be Todd answering your questions. So again, if you want Todd to answer a question about your estate plan, this is your opportunity. The number again is 888-205-2263. One last time, it's 888-205-2263. Quick break, and then right to your calls with Todd Lutsky. As promised, we're going now right to your calls with Todd Lutsky. First in the queue, we've got Paul in New Bedford. Paul, you're on with Todd Lutsky.
Hi, Todd. It's Paul. How you doing today? Thanks for taking my call.
Thank you.
Todd, my parents are protected as far as they're still both alive, and they have a trust where they're protected from the nursing homes and stuff like that. And the house is paid for. Is part of the trust. Now, I'm not sure the bank statements, as far as their savings go, they're distributed into 3 different accounts and under 3 different names as far as their kids as well.
Okay.
My question is, should that savings money be protected as well as far as part of the trust?
So,
Or when that comes a gift, okay.
here's the problem. The name on the account, the name on that bank account or all those bank accounts, is it your parents' name?
It's parents' name and I guess the beneficiary of the kids, I guess.
So not the beneficiary. I just want to know who the name is on the account. It's not in the trust, is it? It's in their name.
Right. It's in their name.
So if it's in their name, and this is very important for everybody, it's a great question. Everybody, if it's in their name, then they're the owners. Now, the beneficiaries may be the kids, and if it is the kids, when that all that means to you and anybody who's listening is that item would avoid probate. So it would, if when they die, it would go directly to those beneficiaries, which would be the kids. It simply avoids probate and nothing more. When I say nothing more, because you have an irrevocable trust with the house in it, and assuming the house was in there for more than 5 years, then that house is not only avoiding probate, much like this bank account is, but it's also protected from the cost of long-term care, which is a nice bonus. This case, the bank account is not protected at all from the cost of long-term care. Just because it has beneficiaries on it does not provide any protection from the long-term care. So my advice to you, if that's your question, would be if they want to protect some more assets, change the name on the account to the trust. Some of the assets, obviously they don't have to put everything in, whatever piece they want to put in, whatever piece they want to protect, change the name on the account to the trust and add some money to it. And that will create a new 5-year waiting period for them for that new addition, but at least it will avoid probate and provide some protection. So hope that's helpful. You know, folks, in that along those lines, I wanted to talk to you about this guide just for a minute, because in this case, this is what's confusing to people. And, you know, when they set up this irrevocable trust, did they make it a gift? Was it a completed gift? No, not all the time, right? I don't know about their trust, but I can tell you that many trusts are designed as incomplete gifts. So just because you hear the word irrevocable, don't necessarily mean that you gave the asset away. And I think it's important when you think about gifting what the right thing to do is. Here, if they wanted to give away those bank accounts, that would create a 5-year waiting period. But from a Medicaid standpoint, and I'm not sure what the income tax ramifications would be. So you need to think about Medicaid issues, income tax, estate tax, you know, gift tax when you're making these gifts, how to gift them, and maybe not gift them outright, maybe put them in an irrevocable trust. Folks, there's so much to think about when it comes to gifting. If you want to learn more about how to gift, get the guide, to gift or not to gift, the tax implications to consider, and of course, many of the pitfalls. You can get that guide by calling 866-848-5699 or legalexchangeshow.com. Download it for free. Again, 866-848-5699 or legalexchangeshow.com.
Todd, prior to the last break, we were talking about, you know, some of the reasons maybe not to make a gift, and you outlined, you know, a couple reasons why someone might not use gifting as their estate planning strategy. Let's say that someone goes through that analysis and says, you know what, I do have an estate that's bigger than the federal estate tax exemption, even, you know, when accounting for 2 people. Yes, I know that I might be gifting something with a low cost basis, but hey, I think this makes sense for me for one reason or another. What types of options does that person then have to really maximize the value of their gifting? How do they go about structuring it if that is what they want to be doing?
So, assuming we are at that point where, and gifting can make sense, certainly, I think the idea of how to gift is as important as why we're gifting. So, according to your scenario, Chuck, we've gotten over the why. We know we want to make the gift.
Yeah.
How do we do it? Well, I never feel like just giving assets to children is a great idea. Putting it in their hands is a great idea. I think that they should probably consider some kind of a gifting trust. So if it's real estate or money, doesn't matter, we can take the asset, transfer it to an irrevocable trust. I know a minute ago I said some irrevocable trusts are incomplete gifts. Other irrevocable trusts can be completed gifts.
Mm-hmm.
So in this case, we would transfer the asset to an irrevocable trust, and you could even put the kids on as trustees. Let's say there's 3 kids, and we want them to share in it. Now, why did we do that? We did that because the language in the trust says income and principal can be paid out to the kids in the other trustee's sole discretion. Okay, so that means they can enjoy the asset that you gave them while they're living. That's good. Even the grandkids can enjoy the asset while you're living or while they're living because it's in the trust. So we didn't not give it to them. They have access to it. But because it's owned by the trust with this discretionary distribution language, if they don't own it, it's now not subject to their creditors. So let's play out the string.
Yep.
Let's say Billy, one of the kids, gets a divorce. And in the trust, there's a bucket designed for Billy with $1 million in it.
Yeah.
Billy's spouse's attorney is going to say, hey, you know that trust that your in-laws set up that you are a beneficiary of? I'd like half. Well,
yes.
Why not? That's what divorce is. So at that point, Billy's going to say, that's a really great idea, but you have to ask the other trustee if they want to make a distribution, and they don't have to. And it's not just because they don't have to. It's all about ownership, folks. Who owns that $1 million bucket? Not Billy. The trust does. So if it's not owned by Billy, then it's not really a marital asset to begin with, is it?
Well, you tell me.
I'm telling you no.
You're the person. You're the person who's qualified to speak on that. So here's my question on that specific topic.
Yeah.
That trust provides that protection. Let's say that I had made the gift into the gifting trust.
Yes.
If and when I pass away,
Mm-hmm.
can that trust continue to exist after I'm gone to provide that protection for a longer time period, or does that trust have to dissolve once I'm no longer alive?
Great question. Again, it's the trust that keeps on giving, if we want to say it that way, because at your death, I could have language in there that says, hey, you didn't own it on your death, therefore it's not included in your estate for estate tax purposes. We've got some generation skipping tax benefits going on here, and the asset then would pass down to a bucket for your kids, the grandkids, right? So your kids, and your spouse doesn't get it even if you're married, and therefore we are able to get another set of assets down another generation without the government taking their haircut, right?
Yep.
So that is a huge win. Keeps it in the bloodline, keeps going all the way for those kids and their life. And then at that point, ultimately, it does have to end.
Todd Lutsky, appreciate you joining us today.
Always a pleasure. Thank you.
The views expressed in this segment are solely those of Cushing and Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing and Armstrong do not endorse each other and are not affiliated.